present, I declare the motion passed. Conservation of Antarctic Marine Living Resources Bill. Members' motion. Ms. Starry LEE will move a motion under Rule 49E(2) of the Rules of Procedure to take note of the Fugitive Orders, French Order, which is included in report number 9/1819 of the House Committee, laid on the table of this Council. In this debate, each member, including the mover of the motion, may only speak once and for up to 15 minutes. After members have spoken, I will call upon the public officers to speak. Then the debate will come to a close, and the motion will not be put to vote. Members who wish to speak, please press the Request to Speak button. I now call upon Ms. Starry LEE to speak and move the motion. President, as a chairman of the House Committee, I move in accordance with Rule 49E(2) of the Rules of Procedure, move a motion on as appeared here, so that the members can have a debate on the report number 9/1819 of the House Committee. The question before you is that the motion moved by Ms. Starry LEE be passed. Does any member wish to speak? Mr. Dennis Kwok.
咁喺呢一個小組討論呢一個。
I'm a member of the Bills Committee or the Subcommittee on the Fugitive Offenders Ordinance. A series of questions were raised at the subcommittee meetings. I'm not going to go through them now, but I want to point out one thing. In Article 13.3, subparagraph 3 of Article 13 of the order, it says that for Hong Kong SAR, the provisions of Article 13 shall not affect the arrangements for the surrender of accused or convicted persons between Hong Kong SAR and any other part of the PRC.
For the surrender of accused or convicted persons between the Hong Kong Special Administrative Region and any other part of the People's Republic of China. 嗱，佢呢一個部分。
Now, regarding Article 13, subparagraph 3, members of the subcommittee had a rather lengthy debate and discussion on this provision. As we all know, the Hong Kong SAR and the People's Republic of China have no specific arrangements in relation to the surrender of accused or convicted persons. That is to say, we have no SFO arrangement between with the PRC. So this article is rather peculiar. Why is it that the article provides that it shall not affect the arrangements for the surrender of accused or convicted persons between Hong Kong and SAR and any other part of the PRC? Basically, we have no such SFO arrangement at all. Why should it be included in the agreement? Does it mean that in the future there may be such an SFO arrangement between Hong Kong and any other part of the PRC on the surrender of accused or convicted persons? We put this question to the administration, and according to the administration's written response, indeed negotiation is underway, and in future there could be agreements with the PRC on how the accused or convicted persons should be surrendered. So negotiations is underway regarding this SFO agreement. We ask for the specific details and the progress of discussion because this issue is really close to the heart of Hong Kong people. If negotiation is already underway, and if you start including such a provision in orders such as this Fugitive Offenders France order, this provision looks really vague and generic. Now, if you suggest that any SFO agreement signed with other jurisdictions shall not affect any arrangements for the surrender of fugitives between Hong Kong and any other part of the PRC, objectively, what will happen is that in the future, if there is a request from France for the surrender of an accused or convicted person, and if subject to the future SFO arrangement with PRC, we are required also to surrender this person to the PRC. According to this provision, Hong Kong SAR government should ignore the request from France and instead surrender this person to the PRC instead. This will be the objective consequence of this article. Now, the consequence is serious because Hong Kong enjoys judicial independence, and yet Hong Kong must not reject the request for surrender of a fugitive from the PRC. And Hong Kong SAR must ignore any request from any other country, such as France, for the surrender of an accused or convicted person. We must accede to the PRC's request for surrender of accused or convicted persons. We ask about who drafted this provision, because somebody must have made the policy decision, and the DOJ was unable to tell us who made this decision, who said that in the future, after we have signed SFO agreements with any part of the PRC, that SFO agreement must override any other SFO agreement signed with any other jurisdiction. We are an independent common law jurisdiction, but we should totally ignore all considerations under the common law system. Because if more than one country requests Hong Kong to surrender a certain fugitive, say if there are concurrent requests from France and the United States for the surrender of fugitives, the court of law in Hong Kong will need to consider the following. For example, about the surrender request of the person, what offense the person has committed, whether there is a similar offense in Hong Kong, whether it is an extraditable offense, and the length of sentence once the person is convicted, and the background of the person. The court may, based on the merits of the case, consider all these factors before deciding whether this person should be surrendered to France or United States or any other country. However, because of this provision, if there are concurrent requests for surrender of a person from France and the United and mainland, for example, we will need to surrender this person to the PRC only. The court will have no discretion in deciding on the factors I mentioned. And this will be a rash decision because at this stage we don't know what SFO arrangements we have with the PRC. And it will be very controversial if we already include this provision now. In the future, when we sign SFO agreements with other jurisdictions, we also need to include the same article. And that is, should there be SFO agreement signed between Hong Kong and any other part of the PRC, such an agreement will override any other agreement signed between Hong Kong and any other jurisdiction. I must say that this is groundless, this is rash, and also with so many uncertainties about the SFO arrangements to be entered into, we are compromising our judicial independence. And there are also other questions. For example, if there are other arrangements entered into between Hong Kong SAR and the PRC, will they carry the same overriding effect over arrangements made with other countries? For example, if an accused is in Paris and if Lyon or France requests the government of Paris to hand over the person to Lyon for trial, then of course the authority in Paris will ignore a request from a place like Hong Kong and instead surrender the person to Lyon for trial. That sounds reasonable, but under one country, two systems, it's a different picture. It is not an accurate simile, because in France, is a country itself. There is no country, two systems, whereas in Hong Kong, we have a different jurisdiction. We have an independent jurisdiction separate from the PRC. There is no relationship between the two, and there is no connection between the two jurisdictions. Does it mean, in other words, that we are subsidiary to the jurisdiction of PRC? Well, of course, some may say that it is, of course, the case because the PRC constitution is also applicable to Hong Kong. We do not accept that. It's not a platform for us to discuss whether the constitution of PRC should apply to Hong Kong as well. And the Civic Party's stance is that, of course, it is not true. And also about one country, two systems mentioned in the article in section 31 of the Constitution, and high degree of autonomy, etc. This is the origin of one country, two systems. We're not going to debate that. But when it comes to SFO agreements signed with the PRC, if it means that we need to totally disregard our discretionary power and other factors that the court may consider, this just doesn't do. Because under one country, two systems, we are an international city. We enjoy judicial independence. And this article will have a great bearing. We hope that in the future, when the administration puts forward other fugitive or offenders order, they can spare with this article because it is vague and rash, and it is disregarding the judicial independence that we should enjoy in Hong Kong. I so submit, Madam Deputy.
Does any other member wish to speak? If not, then I now call upon the public officer to speak, then the debate will come to a close. Secretary for Security. Madam Deputy, I'd like to thank the chairman and members of the both committee for scrutinizing the Fugitive Offenders France order and provide valuable opinions. Hong Kong has all along been supporting mutual legal assistance in the international community and strived to combat crime together with other legal jurisdictions. In accordance with Article 96 of the Basic Law, with the authorization of the Central People's Government, Hong Kong can make bilateral agreements with foreign states for surrender of fugitive offenders to prevent criminals fleeing to another country to avoid a judicial trial. Hong Kong and France in May 2017 signed an agreement on surrender of fugitive offenders, and it is the 20th of such agreement signed with other legal jurisdictions. The France order seeks to provide a legal basis based on Section 3(1) of the FFO, a basis to the agreement signed between Hong Kong and France. The France order has set out the legal protection for surrender of fugitive offenders under the FOO. These legal protections included: 1, the relevant acts must be considered as offenses in the laws under the two places, what we normally call the principle of double criminality. 2, the same act cannot be tried for a second time. 3, the person should not be surrendered where he will be prosecuted on grounds of race, religion, sex, nationality, or political opinions. 4th, no surrender to a third-party legal jurisdiction. And 5th, no surrender in the case involving death sentence. These protections are listed in the SFO agreement between Hong Kong and France and apply to every case of surrender of fugitive offenders between Hong Kong and France. All along, Hong Kong and France have strived to combat crime through international cooperation. The two sides have assigned agreement on mutual legal assistance, and that took effect in 1999, and the agreement related to surrender on convicted persons took effect in 2008, and the France order takes cooperation of the two sides on criminal matters to a step further. I'd like to thank the Bills Committee, Mr. Dennis Kwok, for his speech just now. The members are mainly concerned about the drafting of concurrent requests, and Article 13 of the basic of the order sets out the party to the agreement, requires from the other party the agreement and other state, and how such requests should be dealt with. And this has to do with the seriousness of the offense and the place of commission of the offense, the respective dates of the request, the nationality and ordinary place of residence of the person, and the possibility of subsequent surrender to another place. Clause 13, Article 13.1 and 13.2 aim to specify that if a party to the agreement receives requests from the other party to the agreement and another state at the same time, how such requests should be dealt with. As Hong Kong is part of the PRC, Article 13.1 and 13.2 are not applicable to requests from other parts of PRC to Hong Kong. In the circumstance, the addition of Article 13.3 aims to ensure that the operation of Article 13 of the agreement will not affect the future SFO arrangement between Hong Kong and any other part of PRC. In fact, in our negotiations with different places in the past, the relevant agreements may contain provisions which are not the same. These go to reflect the understanding of both parties and that there is room to deal with different circumstances. President, under the one country, two systems and basic law, Hong Kong can enjoy the right to sign SFO agreements with other countries that can help Hong Kong align ourselves with the international community and joint international efforts in combating crime. And this is in line with the FOO, and the France order is no exception. I once again thank members for their hard work in scrutinizing the France order. In accordance with Rule 49E9 of the Rules of Procedure, I will not put any question on the motion. Motion under Article 73(5) and